right, back at it on this beautiful Monday morning. It's the Scott Sloan Show on 700 WLW. So much to cover between the election and, of course, the tensing trials. You heard breaking news. A juror asked the judge and saying, look, I have a fear for my anonymity and my security. Can I be dismissed? The alternate by Judge Megan Shanahan was dismissed. And this case, of course, has grown. You can't get bigger than a presidential election, especially when it's as hotly as contested as this is. But I'll tell you what, the Ray Tensing trial, starting Friday with all the news coming out, and now with the latest this morning, just continues to, I think, capture our imagination, our attention here in the city of Cincinnati. Because, first of all, it's local, involves a police shooting, and a white cop, black suspect in this case, or victim, is depending on how you want to look at it. But Dr. G.M. Cox is here. He is with Tarleton State University in Texas. He has spent 4 decades in law enforcement, primarily as a police chief, but now is in the Department of Public Administration at Tarleton State. And I wanted to bring an outside set of eyes on this because everyone we spoke to and speak to on the show here regarding this case is from inside the fishbowl, so to speak. And when you look at this, maybe without knowing the history of Cincinnati and what we've done with the collaborative agreement, 2001 riots, etc., to get someone else's take on it, a fresh set of eyes, I think it'd be interesting. And Dr. Cox, good morning. Welcome to Cincinnati. How are you?
Good morning, Scott. Glad to be here.
So the use of force, you saw the video of the Ray Tensing trial of Sam DuBose. Use of force, what do you see when you look at this as a police officer?
Well, I mean, any use of force is going to create a number of reviews, and I think that's important. So you look at it from basically 2 angles. One angle, was it justified? And that's a legal issue. And that's really what's going on right now when you talk about the Ray Tensing trial. Was it a justified shooting? I think clearly the grand jury or whatever system y'all use for indictment in Cincinnati clearly decided that was not a justified shooting. Then on the second one, you got this court of public opinion that looks at every use of force. Was it right or was it wrong? So you got 2 hurdles to get over. One is the legal, and then 2 is the public opinion. And from what I've seen in the news, you really, right now with the story you just let in with, you have an alternate decided, hey, I need to be out of this because there's way too much threat. I'm not feeling comfortable, et cetera, et cetera. If I'm the defense in this case, I'm really worried about, can I get a fair trial in Cincinnati, Ohio? If I'm the prosecutor, he or she's got the same concern.
Yeah, that's interesting because today, as I said, it just broke less than a half hour ago that a alternate juror said, I have a fear for my security. To bring you inside what we're looking at here, the jurors went to the crime scene and they had to get vans with tinted windows. They cordoned off the whole area, took down any of the memorials to Sam DuBose. A neighbor came out and was attempting to video the jurors inspecting the scene, and essentially they had to negotiate, say, look, we're going to hold you in contempt if you do anything like that. And so extraordinary circumstances have arisen that have afforded, I guess in this case, the law enforcement community to protect as best they can the anonymity of these jurors. But then you hear stories about individuals going, hey, I think I may be compromised here. And I know what you said, but does this also provide a slippery slope, meaning that other jurors are now freaked out that an alternate got out? Do we have a parade now of people coming before the judge going, I got to get out of here too, I'm scared?
I'd be very concerned about it, quite frankly, and I'm not sure you can guarantee the anonymity of a jurist. That is basically the premise of the judicial system in the United States is free and open trials. The public has a right to view that trial, and then therefore also has the right to know who the decision makers are, in this case, the jurist. So I'm not sure. I don't know how you're going to keep the anonymity down, and clearly it's going to come out. I mean, the media is already on it. They're going to get those names. Mm-hmm. If I were a jurist, I would be very concerned for my safety, particularly if there's been directed threats, and certainly indirect threats.
Late last week, actually Friday after I got off the air, Dr. Cox, the judge released or was required, I guess, by law to release the jury questionnaires. I know they redacted the names and some information, but our local newspaper, The Inquirer, wanted that information, and she was going to release it. And finally, because of the outcry, I think The Inquirer backed off. But that would scare me if I'm in a jury and I'm going, well, it's a 140 questions asked, and I had to put names and specifics down there. It would worry me greatly that if that information got out and publicized, it would compromise my anonymity in this case. And so, fortunately, I think the Inquirer, they said, okay, maybe we don't want that badly, but the process has to be transparent. But at the same time, you've also got to protect the safety and security of the people making that decision. That's a fine line to walk.
I absolutely agree. Jury intimidation, whether it be for acquittal or for conviction, is just as bad. In a system of government we have, in the judicial system we have, a person is presumed innocent until proven guilty. Officer Tensing has a right, and this is declared in the Constitution of the United States, has a right to be considered innocent until proven guilty. And that requires a judicial review. It also requires it meets a legal standard of proof. The public opinion does not stand in a courtroom. It has no bearing in a courtroom unless that public is intimidating the jury. And then that is a genuine concern. The judge should be genuinely concerned about this. The prosecutor should be, because the prosecutor's first and foremost job is to see that justice is done, and done within a legal framework that supports the legitimacy of the courts and the trust in that institution.
Breaking news this morning in the Tensing trial, a juror asked Judge Megan Shanahan to be excused simply because they feared for their security and their anonymity, and was afforded that by the judge. Dr. G.M. Cox is with Tarleton State University in Texas, longtime law enforcement officer, police chief, and also expert in public administration. Some outside eyes, as we say, joining the show this morning on 700 WOW with Sloaney. On trial here is the definition of the appropriate use of force, and there's many factors in that. It's a split-second decision. I'm sure that many people go, if the jury's armchair quarterbacking this and looking at video in milliseconds, that's something that Ray Tensing was not afforded at the time this whole thing went down. But can you describe to me the appropriate use of force, and if it, at the very least, met the standard from what you saw in this video?
Okay, so there's a couple of things, and you asked some great questions, Scott. First, what's the constitutional limitations on use of force? And obviously we've got to go to the Fourth Amendment. The Fourth Amendment says no unreasonable searches and seizures. So shooting someone's a seizure. We got now three U.S. Supreme Court cases that basically try to create a definition of reasonable force, and or in this case, when you shoot somebody, that's a seizure as well. So you've got Garner versus Tennessee, which is a fleeing felon, unarmed, and similar to this case. But it clearly shows that case, the Supreme Court came firmly down and said you cannot shoot an unarmed fleeing felon that poses no immediate threat. That's one. Now, two, you got to go to Graham versus Connor for the second landmark case of the Supreme Court, which basically says you can't substitute the decision of the officer on the street with that he or she was facing at the very, very moment of the use of force in a room full of air-conditioned lighting and no stress. So you've got and that's called the reasonable officer standard. So now we've got the Supreme Court saying, wait a minute, you can't dissect what this officer did in a millisecond in a courtroom or anywhere else, what we call Monday morning quarterback.
Sure.
What you got to ask is, would any other reasonable officer have acted in this manner, given the set of circumstances this officer faced? Now, that's a very, very interesting ruling when you compare it with Garner versus Tennessee.
Yeah. So they seem to be at odds with one another.
Yeah, I mean, so all you got to do is find one other reasonable officer says, yeah, absolutely, I think that's legitimate use of force. Now, here's the thing: the jury gets to decide which officer they're going to believe or which witness they're going to believe. So let's just say that the officer Tinsley says this guy was going to drive over him, at him, et cetera, et cetera. So, and he believed his life was in danger. Now, I got to say, the courts have been firmly, and this is, of course, case law has supported this. If the officer's true belief is that his life was in danger, or anyone else's life was in danger, then he or she is justified in using deadly force to stop that action immediately. Now, again, but that's why we have a judicial system. And people will sit there, the 12 people in this jury will decide whether that was a correct statement. But they have to, I know this defense attorney's he's got lined up officers that have viewed this, experts like me. They're going to come in and say, yeah, I think it's justified shooting based on what was going on at the time. Mm-hmm. This is what I see in the video. It's happening. You're looking at it over and over and over in a loop This officer saw it for 1 point, less than 1 second, and made a decision. And you've got to ask yourself, would any other officer, reasonable officer, do this the same way?
Which is the great question, too, right? It's obvious when someone is armed and harming others. I saw a video over the weekend of, I think it was in Oklahoma, guy shot 3 people, was firing at, I saw a tactical officer in the backseat of a squad shooting at the car while it was moving. Incredible chase. And there's no doubt that's an appropriate use of force in that case. But why in some cases do you use lethal force and others you don't? That's got to be up to the individual interpretation of that particular cop.
Absolutely, but that's why we have Graham versus Connor, is for that set of circumstances that led this officer to act in one way may not lead another officer to act in that way, and that's why you've got a trial. In this case, I'm sure he's being tried for a state criminal statute. Now, most of what the Supreme Court has talked about is civil statutes, but the courts can take notice based on these legal standards. So if I were the defense, I'm going to be hammering that, and then if I'm the prosecution, I'm going to try to negate those issues and clearly go with intent. Obviously, they're prosecuting for murder, correct?
Mm-hmm.
So there's a bright line. That is a purposeful intent. What we call you must be intentionally, knowingly acting in a way that you know is going to cause serious bodily injury or death to the individual directing it. Now, question is, does he have a right under state law for self-defense? So if he has a right under state law for self-defense, then that's a slam dunk. The question is when it's in this gray area like it is right now, can the officer, and then there's a third case that came out of the Supreme Court that just recently came out about a couple of months ago that says officers can use deadly force to end an action that is clearly reckless and could cause serious bodily injury and death if allowed to continue. Now, that's a very interesting ruling there, is that an officer now is allowed to use basically intuition, training, and experience to kind of predict the outcome, assuming that the behavior that you're witnessing continues after the opportunity to use deadly force. Does that make sense?
Yeah.
So,
that's interesting.
This was a high-speed pursuit of an individual going the wrong way down a freeway. They had a counter sniper on the overpass. The decision was made to go ahead and shoot the suspect, because if he had continued on, he was going to likely cause serious bodily injury and death to other people. And the Supreme Court recently ruled like that just a couple of months ago. So that's a very interesting ruling as well. So we see this bandwidth of legitimate force being used by police officers in situations that most citizens will never, ever find themselves in.
Yeah, and yet they're the ones who have to judge the cop, and that's what makes these things interesting, too. Before I let you go, real quick, Dr. G.M. Cox out of Charleston State University in Texas. You're also in the public administration sector now, too, and that encompasses public safety, obviously, outside of policing. Here in Cincinnati, in this case, we have people who are protesting outside, rightly so. We suspect, like we have seen in other jurisdictions, that there are people, not necessarily locals, but we believe that there's going to be interlopers, people coming from around the country in order to have a say in something that's happening here in Cincinnati. How do you, and learning what we learned from Ferguson and elsewhere when it came to protests, how do you manage these protesters properly, allow them to have their voice, but at the same time make sure that it doesn't turn into riots? How do you do that based on what we've seen in the past?
Well, it's like the Assistant Chief of Cincinnati said, it's a trade-off. You have the interest of the public safety, but they also at the same time he's got the people in decision-making positions have to worry about what's going to happen in the decision-making. In other words, are we going to have unfair jury tampering, whether it be through intimidation or direct contact? I mean, these jurors are not going to live in a cocoon, and they're living in that community. So, but I think at like you said, Cincinnati is very accustomed to handling these kinds of riots or protests, and I think they'll do a great job doing that. I've seen Cincinnati's police, very well trained people, respond to these kinds of situations. I'm sure they've got a battle plan, response plan, if you will. Maybe battle's a bad word, but it's a response plan where they've got. And they're doing the right thing. They're reaching out to the community leaders, creating a dialogue. Let's say, what can we do? We want you to have your First Amendment right, freedom of speech. But let's keep the freedom of speech within the legal bounds of peaceful speech, actions that don't cross the line into a riot. And I don't know what's Ohio's definition of a riot, but it's a pretty easy one. In Texas, all you got to have is 7 or more people start creating a disturbance, and now you've got a riot, depending on the level of
Texas is a little bit different. I'm sure you know that compared to other areas, a little bit different. But Dr. G.M. Cox, I appreciate the time from Charleston State University in Texas regarding the Sam DuBose and the Ray Tensing trial this morning on 700 WLW. Thanks again.
You're welcome.
Appreciate it.